Welcome to Enterprise Unleashed, business law and innovation with experienced business strategist and trial attorney Richard P. Corey. Nicknamed the Closer, Richard prides himself on striving to maximize his clients' desired outcomes in both transactional and litigation settings. I'm Evan Mack, and today we're unpacking how airtight contracts protect your business long before dispute ever reaches the courtroom. Richard, sir, welcome back.
Evan, what's up, man? I'm glad to be back with you.
Good, brother. Good to see you again, man. Last time we checked, I seen you with a DJ. I kind of laid out, watch you guys work, but it's good to see you, brother.
Yeah, no, that was a good episode. That was good. That was the one with Chops,
It was good. So why do so many business disputes trace back to the language of the contract itself, Richard?
right? Every time I get a case where it's like, wow, how are you in this position? It does always come back to the contract language that governs the party. So think of that as like the foundation of your building or anything you're doing. It all starts with the contractual terms. And when you have terms that are unfavorable or ambiguous, that leaves room for interpretation, and everything goes well until there's a dispute. So one of two things happen, especially in startups. Either people fight because they're making money or they fight because they're not making money. And it all comes down to how the contract, like your contract, your operating agreement, your shareholder agreement, partnership agreement, the terms that are going to dictate who gets what, when, where, and how, and also everyone's obligations, their what they need to do for the company. So I mean, it all comes down to having a very carefully structured agreement.
So, Richard, what are the key elements, though, every entrepreneur should confirm are present before signing any commercial agreement?
I mean, there's no one size fits all. It depends on what you're doing. So the most, like a lot of people, they'll go and they'll get like what they think is a standard agreement, but there's no such thing. You have to tailor it specifically to your business and specifically to your needs. So, if a contract says two people have equal voting rights, but then what if they disagree? You're in a deadlock. One person wants to do one thing, the other person wants to do the other, and you have no mechanism to handle that dispute. Now what? The only thing, that just reeks of litigation, and all that can be avoided if you discuss those things from the onset and put that in writing. Because at that point, everyone can say, "Look, you agreed to this. We discussed it. You had your attorney negotiate it. My attorney negotiated it. Now there's no room for argument. There's no surprise." But a lot of these contracts, I see it all the time where people think, yeah, this doesn't matter. And it's those things that come up and bite you right in, Also, like duties of loyalty. There's, who's doing the accounting, who's handling the money, who's handling distributions. Oh, this person put up this amount of money, or this person needs to put up this amount of money. Is there a capital call? What happens if let's say you and I are 50-50 partners and we need a $50,000 investment, and let's say, all right, we have what's called a capital call. So that means we both each have to put up $25,000, but you don't have the money. Now what? So how is that handled? Do I have to put up the money on your behalf? Does that dilute you down? So there's all these things. And if it's not handled in your agreement, typically it'll revert to statute, but it's not as specific. So the most important thing is to structure the agreement, narrowly tailor it to the specifics of your business. So there really is no one size fits all. I mean, it depends on what you're doing. You know what I mean? Like it'll change depending on the industry, depending on the type of business, depending on how the partners are, how they intend to like work and operate with each other. So there's a lot of factors that go into it. There really is no one size fits all, and that's why it's important to have an attorney look over it before you go and sign something.
Rich, what about like unclear or maybe those recycled contracts that have those the basic template? How does that expose a company to liability if it never intended to assume?
Well, a lot of those agreements, they're like standard clauses, what are advertised as a standard clause. There really is no such thing, and most of those are pretty broad. So there's a lot of terms that are ambiguous, and when there's an ambiguity, that leaves room for multiple interpretations. So again, if I read it one way, you read it the other, and we disagree, that's where the problem starts. so that you want to get as specific as possible, because the more specific you are, the less room you have for alternate readings of the clause. Does that make sense?
It does. It does. But when you draft or review these contracts, what indicators tell you an agreement would hold up under this, maybe courtroom scrutiny, perhaps?
It does come down to case law. So you got to look at, all right, these types of terms are typically handled this way in a courtroom. These types of terms are handled this way. So that comes with experience. So part of my job is to know what holds up in court and what doesn't. For example, let's say you and I are partners and I want to make you sign a non-compete agreement, but it says you can't work anywhere in the state of Florida, yet we have a barbershop. Like, why would you be prohibited from opening up a barbershop in Orlando when our barbershop is in Fort Lauderdale? Like, that
Right.
doesn't make sense. That's a complete ban on trade. That'll never hold up in court.
Mhm.
But if it's something where you're operating on a statewide level or on a national level, that's a totally different thing. So again, it really comes down to like what you're doing
Hmm.
and the specifics of the business.
How should a business owner, though, approach negotiations so that these agreements stay firm but still preserve those good relationships with the other party?
Well, the first thing I would say is never be your own mouthpiece, because a lot of things I tell my clients is, look, let me be the bad guy. That way, if we go into a negotiation with a potential partner and they don't like what I'm saying, they can come back and just blame it on me. They can be like, look, Richard's a jerk. It's his fault. That's not what I wanted. They let me be the bad cop, which is
Mhm.
fine. That's my job. I mean, it's I don't take it personally. It's what I'm paid to do.
Right.
But when you're going into business like that, you do need to hash out like everything as much as possible, because in my experience it's always going to be the things that you didn't expect to come and bite you that end
Mhm.
up coming and biting you. And someone will say, oh, this is a very fair contract, it's standard stuff. That's not necessarily true. But you always want to have a fair deal. You want it to be fair, but all things considered, depending on who's putting up what, who's in charge of what the responsibilities are,
Right.
what may be fair to you may be completely unfair to someone else. What you want is something that's fair to all parties involved.
But Richard, what's the smartest way to address that dispute resolution clauses, for example, through arbitration, mediation, litigation, so they actually work in practice?
Well, again, that's another thing. It's all a matter of preference. So I've seen a lot of agreements that say, okay, before anyone can file suit, you have to do a mandatory mediation. And that sounds good because it's like, well, before you can jump into litigation, you have to give your best efforts to resolve it. But if that clause is not written properly, anytime there's a disagreement, it could be read that you have to go to mediation. So you guys fight one day, you got to mediate. You fight the next day, you got to mediate. That becomes very expensive, and that in and of itself becomes a pain in the ass. So
Yeah.
that's not what you want too. So again, like arbitration provisions, I don't really like them because there's very little room. Like if you go to arbitration and the arbitrator gets it wrong, then there's very little room for change. So it's
Hmm.
unlike in a regular like lawsuit in a state court or in a federal court. You can if you have an unfavorable ruling, especially like a final judgment, you have the opportunity to appeal. You can take it up to a
Hmm.
higher court and explain why the judge got it wrong. With
Hmm.
arbitration, there's not as much room for that. So if it's really one bite at the apple. So if the arbitrator makes a decision that's unfavorable, you're pretty much stuck. Now there is opportunities to appeal or to have things reconsidered, but it's just not as prevalent. It's not, you don't really have as big of the opportunity, and there's also very strict timelines. So I've had a couple clients where they go into arbitration. Arbitrator gets an award, and I'm looking at it's not like I wasn't part of the arbitration, and I'm
Right.
looking at the award like, wow, how did this even happen? How did you even lose this? But because there was a 90-day window by statute that went by, there's no opportunity to fix it at all. So I've
Wow.
even seen arbitration awards that are contrary to law. They
Hmm.
actually have no basis in law or fact, but they're enforceable and then turned into a final judgment into a court, and yet they're contrary to the law itself. But
Damn.
because there was that window to seek modification expired, everyone's stuck.
Rich, I'm sure you've seen this before, but many founders, partner with their friends or family. What should those partnerships document maybe at the very beginning to kind of prevent conflict later?
see, that's the thing. Like I've done it myself. You go into business with your friends and family. You're like, oh, we
Yeah.
could do this on a handshake deal, which
Yeah.
should be like that on the surface. But I think in those situations, it's even more important to have a contract because it's one less thing to argue about. When you go into business with family, you're risking a lot more than just business. It's your familial relationship. So
Mm.
you want to outline things right from the get go. Who gets what the terms are. And that way, moving forward, because you got to separate family and business. There's something that is very important. Even in my experience, you do a handshake deal, and people will conveniently forget what they agreed upon. When it makes sense for them, they'll say, okay,
Yep.
yeah, I'm going to do this, this, and this. But then when it comes down to it, they're like, no, I never said that. And you're like,
Right.
so those are problems that I think even when you're in business with friends and family, it's even more important to have a contract. That way,
Yeah.
you don't risk losing a friendship or damaging your familiar relationship because there's something arises that you didn't anticipate from the getting, or someone conveniently forgets what they said or what they were required to do. You know what I mean?
Yeah, 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 yeah. From your experience, though, Richard, like the litigating contract cases, what patterns do you see that business owners could easily avoid with better preparation, or just following what you were saying these past questions?
Well, I mean, I just had a hearing this morning, and it has to do with equity in multiple companies, and the whoever drafted the agreements did a sloppy job. So there's like it'll say, okay, well, if this and this happens, it's governed by this provision, but they have the wrong provision, or it refers to like a different subsection. You're like, wait a minute, this has nothing to do with anything. So now that just invites disputes, especially once you start getting into bigger business. So most of my clients, I deal with a lot of startups, but as I've progressed in my career, I mostly deal with larger companies that are doing acquisitions up to 8 figures. So, it's very important that you are extremely meticulous in when you're drafting these agreements because those little Scrivener's errors can become multi-million dollar problems.
It's crazy.
Like uh, things like do you know what a tag along provision is or a drag along provision?
No, let me know.
Okay, so there are provisions in a contract that say, well, if somebody comes and they want to buy my stock, you can require them to buy your stock too,
Mhm.
or I can require you to sell. Now,
Hmm.
what happens if we're in business, we're doing well, and I try to enforce one of these provisions,
Hmm.
but you disagree on the price. I'm now forcing you to sell for what you believe is much less than the value that your stock is worth.
Wow.
Nothing you could do about it.
Wow.
So when it comes to, I'm looking at like, look, I want out.
Yeah.
This is going to be my payday. I want out, and the, I'm trying to figure out an example. But I want out. You want to stay in the business,
Yeah.
and um, the valuation, the buyer doesn't only want my stock. They'll only buy it if they take yours too. So now I'm
Wow.
forcing you to sell, but you don't agree on the price and you don't want to sell. Well, tough. You know what I
That's
mean? Like if it's in the contract, like there's nothing you can do about it. So,
yeah.
you got to be very careful and make sure you understand everything that's going into that agreement. And because these clauses, they all have very serious ramifications.
Finally, though, Richard, for companies executing new deals this quarter, what single adjustment would most strengthen their contracts right at this moment?
Well, again, it just depends. That's like, it's like you're asking for a car. Like, well, what kind of
Right.
car are we talking about here? Are we talking about a
Right.
Bentley or a Honda? You know
Yeah.
what I
Yeah.
mean? So it would have to be like, well, what are your goals and needs?
Hmm.
What are your strategic plans for the growth of the business or for, how you want to move forward? What are your um, objectives? Like, what are you trying to accomplish?
Hmm.
And so what I try to do is that I'll ask those types of questions, and then we sit and work and use deductive logic to reverse engineer the path to accomplishing whatever the goal is. So we'll like break it down. Let's say you want to scale the business up. You want to raise money. You're doing a Series A, or you're raising money. Well, you need to know how to approach the investors. You need to know that, okay, well, yes, we need money, but it's also about getting the right money, not just any money. Let's say you go to a VC company, they're going to probably want a board seat. So
Right.
now if you have now you have these guys on the board that you don't know, the company that you started from the ground up, you could lose control of just by giving up those board seats. So you have to take all these things into consideration. There's no one size fits all. It's a
Mm.
case by case basis. And that's what separates very smart entrepreneurs and skilled entrepreneurs from guys winging it. Now you could do it both ways. Like, oh, look, when I started my practice, I was winging it. I had no idea what I was doing as far as running the business. Like, you know what I mean? Like, I'd never dealt with having employees. So a lot of things I had to learn on the fly. But again, if you're taking the time, it's worth it to have an attorney look over the agreements, because we're an attorney, not just me, but business attorneys are going to be able to see things that you may not see.
Right.
They'll see the possibilities or the risks that may not be readily apparent to you. But you look at the situation like, well, okay, let's say you and I are partners, and we're doing a buyout. You're leaving the company, but prior to
Hmm.
that, you were managing, and I'm going to assume the liabilities now. But I don't know that prior to this happening, you went and took a mortgage out, or you took a loan out on the company,
Mm.
or and you put up the assets of the company as collateral. Now I'm stuck dealing with that. Or let's say you didn't handle the books right, you didn't handle the accounting right. Now we have issues with tax. You get bought out, you leave with your money. Now I'm stuck facing an audit with the IRS, and it's my problem. So you got to be very careful how these deals are structured, and take all of that into consideration. You got to see the forest through the trees.
Richard, appreciate the time, brother.
All right, man. Thank you so much.
Good stuff. That's it for today's episode of Enterprise Unleashed, Business Law and Innovation with my man, attorney Richard P. Corey. To connect with Richard, visit rcenterpriselaw.com. Don't forget to like, leave a review, subscribe, and share this with someone that might find this information helpful as well. Thank you so much, and we'll see you next time.
Yes, sir.